Good morning. Welcome to the Florida Supreme Court. The first case on the docket today is the reprimand of Judge Holder. Judge Holder, we have summoned you here today because of conduct which this court has determined to be in violation of the Code of Judicial Conduct and which now requires us to impose appropriate discipline. As the preamble to the Code of Judicial Conduct recognizes, judges, individually and collectively, must respect and honor the judicial office as a public trust and strive to enhance and maintain confidence in our legal system. The effectiveness of our judiciary rests ultimately on the trust and confidence that people confer upon judges. As a result, one of this court's most important duties is to carry out the responsibility given to us in the Florida Constitution to discipline judges for misconduct. This is not a task I enjoy, but certainly one that we as a court regard as vitally necessary. You have been found guilty of violating canons 1, 2A, 2B, 3B7, and 3B9 of the Code of Judicial Conduct. The charges filed against you arise from you presiding over the 13th Circuit Veterans Court in the criminal case of State of Florida versus Clay Allred. Mr. Allred's case arose from a 2004 confrontation with a convenience store clerk that resulted in Mr. Allred being charged with 2 felony counts: discharging a firearm from a vehicle and aggravated assault with a deadly weapon, as well as 1 count of criminal mischief and misdemeanor. Throughout the period of time that you presided over the case, Mr. Allred was represented by private counsel. On March 27, 2015, you accepted a no-contest plea by Mr. Allred and sentenced him to 24 months of community control to be followed by 36 months of probation. As a consequence of his arrest and subsequent conviction of multiple felonies, Mr. Allred was expelled from and later denied readmission to the University of South Florida. He was working there to complete his undergraduate degree, the completion of which was recommended by the defendant's VA Medical Center staff psychologist. On November 13, 2015, you sent a letter to University of South Florida President Dr. Judy Genshaft. Your letter, written on your judicial letterhead, served as both a letter of recommendation from Mr. Allred and a request that Mr. Allred be admitted into an online-only program at the University of South Florida. You offered Dr. Genshaft to modify the conditions of Mr. Allred's community control to prohibit him from entering the university campus. You also requested that he be admitted to take his courses only as an online student. However, no such online program existed, and your request was denied. You then called the state attorney and suggested, among other things, that he review the evidence and permit the defendant to have his adjudication withheld. The state attorney declined to do so. After speaking to you, the state attorney called Mr. Allred's counsel and informed him of your call and request. Coincidentally, on November 20th, 2015, Mr. Allred's attorney filed a pleading entitled Motion to Modify Community Control to Probation, in which Mr. Allred, through his counsel, requested a modification of his sentence so that the 24 months of community control, his house arrest, could be converted into the less restrictive regular probation. The motion explains that the conditions of Mr. Allred's community control, as well as his extensive treatment regimen, were preventing the completion of his undergraduate degree. Judge Holder, on January 8, 2016, you conducted a hearing on this motion, and you granted, over the state's objection, Mr. Allred's request to modify his sentence. Following an investigative hearing, you entered into a factual stipulation with the Judicial Qualifications Commissions, admitting to the charges, apologizing for your improper conduct, and accepting the public reprimand and 6 additional hours of continuing judicial education training as recommended by the panel. Judge Holder, Canon 2B, specifically states that a judge shall not allow family, social, political, or other relationships to influence the judge's judicial conduct or judgment. Whatever feelings you harbored for Mr. Allred, you went far beyond what judges are permitted under the Code of Judicial Conduct. You place yourself in 2 grossly inconsistent positions. 1, as a judge presiding over a criminal case, or 2, as an advocate pleading the interests of the very defendant who was appearing before your court. You made transparent efforts to provide benefits to that defendant despite the objections of the state attorney, who is the people's representative in criminal matters. We therefore publicly reprimand you for your misconduct, Judge Holder. The conduct you have exhibited cannot and will not be tolerated. By our actions today, we admonish you to correct whatever may have caused you to commit this single breach, and we advise you to remember what our prior cases have consistently held. A second ethical breach by a judge will be viewed far more harshly. Your public reprimand is concluded, and you may leave, sir.
Thank you.